I am meeting today with Alex Falconi of Our Nevada Judges, and some of you may know who that is and what they do, and others may not. So we're going to make sure that those of you who do follow what goes on with Our Nevada Judges will find this very interesting. And Alex has been kind enough to give us a brief overview of how Our Nevada Judges came into being, and then why we're talking about a specific event that arose, which is probably, if not the most important event in the existence of Our Nevada Judges, at least one of them, one of the seminal moments, I would say, at least as an observer myself and as a fan.
Yeah.
Okay. So what Alex and I talked a little bit before we started this interview, that we would talk about why this is why we chose to talk now, and then we're going to just make a full circle by kind of letting you know how it got there. And then in the process, Alex can tell you about why Our Nevada Judges came into being. So, Alex, I'll turn it over to you, and I will interrupt briefly from time to time, but this is your story and not mine, clearly. So let's start out with this. I will set it up. Our Nevada Judges filed an action such that you had oral arguments, not you yourself, but your counsel had oral arguments before the Nevada Supreme Court just about a week ago about this subject. But I'll turn it over to you. So, what were you arguing about, and with whom, in the Nevada Supreme Court?
So it was three different cases. Two of them were filed by our Nevada judges, and then the third one by the largest newspaper in the state, which is the Las Vegas Review-Journal. And it was filed. Two of the cases were filed against the Eighth Judicial District Court specifically, which were cases that were confronting the theoretical unconstitutionality of rules and statutes that interfere with the public's right to observe courtroom proceedings. And then the other case, the third case, was an actual denial of physical and camera access to a family court proceeding. And that one is significant because instead of arguing that these rules and statutes theoretically get in the way of the public to observe, we had an example where we attempted to observe and a family court judge did invoke those rules to close the courtroom doors and conduct the proceeding in secret.
Okay. So, for those who are new to this or somewhat new to this, they may be. So, you're saying the press or the news media, you're arguing for access to family court proceedings? Is that what you're asking for?
Yes,
All
yes,
right.
yeah. And we
And
have,
secondly, are you saying that there are already rules in place for that?
there are rules that get in the way of it. There are
All
rules that,
right, but there are rules that actually do address this. In other words, it was like, oh, this is unheard of. We couldn't even imagine such a thing, right? There are rules that already exist in Nevada for that.
yeah, there's
And then you're
statute.
saying that they were invoked in a manner that was to keep the news media out, not let them in. So, am I with you so far?
Not even just in a manner, that's what they were designed to do. The reason that we've attacked the rules and statutes is because they were designed to close the courtroom doors without consideration of the public's interest, or by extension the press's interest. Sorry. There are different forms of there are different approaches that the rules and statutes take. So for example, with divorces, all one of the parties has to do is say, I want this room closed and cleared out, and that closes the proceeding. For non-divorces, it's just automatically closed when it comes to unmarried couples, and this is purely arbitrary. I mean, I don't want to go into the history of it because it's technical and unimportant, but the issue of whether kids and families and sensitive issues come up in these proceedings isn't really, no, I'm not going to say isn't at all discussed in any of the rules and statutes. It's not mentioned at all. We have those issues come up in any type of courtroom, whether it's criminal, non-family, court, civil. This stuff just comes up, and these rules.
Which I will spoil it a little bit. That even the justices of the Supreme Court kind of said in response to some of these. I will call them lame excuses. Even they were like, really? You're
Right.
trying to say there's like some special carve out for family law proceedings that you claim don't happen anywhere else, when in fact we know they do all the time? That was okay. Okay.
Well,
Continue.
anytime that the question comes up of getting access to the proceedings and being denied access, the instinct of the ordinary person is to assume that one of these sensitive issues came up. But the rules and statutes don't have any kind of contemplation or analysis, or they don't contemplate any of those particular issues that could come up that might justify closing the courtroom. They just arbitrarily close it. And
Well,
that's
what's so bad about that? I mean, these are personal matters. Some would call them somewhat private matters, potentially embarrassing matters. So, what business do you have, or anybody else in the public, for that matter, coming in to watch these proceedings? Why should they? Why should that happen at all?
well, the funny thing about that is going back all the way to the history and the beginning, there wasn't really family courts. I mean, family courts is a sort of specialty court, is at least in Nevada, a relatively new concept. I mean, courts have done family court issues. They just dealt with them in the ordinary civil court process. It's not until states went about and created these statutes that sort of created this concept of a courtroom that only handles this one specific thing. I don't really know all of the history with the other states because when I did my research, I went through and looked at the history of Nevada. But if I recall, the family divisions in Nevada aren't even throughout the state. There's only two of our counties that have them, Washoe and Clark. It's based on how large the county is. And gosh, I wish I could remember what decade they were enacted. I think I don't know, 50s to the 70s. It's not like it was always there. So this idea
Let's simplify it then. Let's just say that regardless of whether it's in what's known as a special family court or just handled by the regular courts as any other civil proceeding, what business does the public have observing what's going on in Kramer versus Kramer and
that's
that divorce action, or this particular paternity action or child custody? I mean, what business is it of yours or any other member of the public, and certainly the news media? Why should anybody have access to this information and know what goes on in these proceedings?
it's the same reason that the public or any media outlet has an interest in covering any type of case. It has to do with trust in the process. This was actually discussed by the Supreme Court of the United States when I think it was the California Supreme Court that specifically said when there is a conflict between the criminal defendant's rights and the public's rights to know what's going on, that the criminal defendant's rights prevail. And SCOTUS actually rejected that. And they rejected it because they said the involvement of the public isn't necessarily to pick a particular side. The involvement of the public is to see that justice is being meted out fairly. And that principle is not just a criminal court principle. That has to do with any kind of court in any type of case. It's odd that people have these thoughts towards family court because everybody has families. Most people have kids, and that's something that I think pretty much the entire population can relate to. So this idea of the public not being interested in what goes on in family court to me is a very weird thing. I feel like the public probably has more of an interest in what goes on in family court than they have in criminal court, which
Because you're more than likely to, if you're going to have contact with litigation and court, it's more than likely going to be in a
right.
family law case, either your own family law case or of a loved one or friend.
Right. So to me, it's almost like they have it exactly backwards. Rather than there being less interest in family court, there should be way more. And the other thing that I find odd is that I think a lot of people jump to the idea of sort of like a watchdog to sort of like keep an eye on the judges and lawyers. And I feel like that, at least for our Nevada judges, is a side effect of what we do. We're really just trying to teach people how it works. And so sometimes coincidentally, these issues of incompetence and corruption or maybe just bad judging come up, but that's not really the point of what we're trying to do. If people see how family court works, it sort of gives them an idea of what to expect if they happen to be there in there, if their family members are in there and they have questions. Not even so much just the specific information of the parties that are in a particular case, but just the format, how evidence is submitted, what people are having disputes over, how custody is meted out, how visitation schedules are set, what happens when people want to relocate. There's all sorts of general
Right.
questions. How it
When
works.
the way I've explained it, when that question has been put to me, is it's the proceedings that not the participants
Right.
that is of interest to the public. Is we want to see what's going on. We want to see how the legal system works. We want to find out what the law is and what the rules are and how they're applied.
Right.
in specific situations, some of which may be like my own. If I
Right.
happen to be a family law litigant or a future family law litigant or something like that. And if you don't mind my saying, I always thought it would be good because I think the courts would benefit from this. Again, not that that's your principal
Right.
purpose for existence, but if the more people know about what goes on in the courts in advance, the less time will be wasted and the fewer mistakes will be made, and fewer irrelevant things covered, because people will say, oh, this isn't my first rodeo. I may be appearing in court for the first time in my case or in my friend's case as a witness, but because I've seen what goes on, I'm not a complete neophyte.
Right. These are all obvious advantages to electronic coverage. And I don't even want to go too much into electronic coverage if we're just talking about the Supreme Court case, because the arguments were just on physical access. That's another thing that I think shocks a lot of people. Most people who watch the video hear about the arguments that Marshall Willick made specific to broadcasting and the internet and YouTube, because those are the more, I guess, those are the easy targets for him. That's the sort of the fear-based approach of all of this stuff being all over the internet. But the Supreme Court isn't even considering that. They're just considering, for this case, whether you can even just physically go in there and sit down. And that just has to do with the fact that for us to get a camera in there, we have to get the right to be able to physically go in. So, I mean, for me, everything that you've described is wonderful in the sense of being able to sit in there and then I guess step out and explain it to the public. But really, you're getting to the point, you're getting to the next step, you're getting to recording and broadcasting. That's really what I think you're getting at, is how do you benefit the family court system by showing the public what's going
Right.
on.
But you had to start with the public's right to access first, because and I know you're going to get there, so I won't steal your thunder, but it's like, if the public has a right to know what goes on in the publicly funded and publicly overseen courts,
Mhm.
then the media is just an outgrowth of the public's right to access and means of access. Take it away.
Yeah, no, that's really all that it is the ability of the ordinary person to observe proceedings for 6, 7, 8, 9 different reasons, rather than be so much obsessed with or interested in a specific outcome. I mean, if you want me to go into anything specific with the case, we can do that. But you shared the oral arguments with your viewers yet? Because that might be a good place to start for them, is to observe those and perhaps do a follow-up if they have specific questions. But I mean, that's really the beginning and end of it, is fighting for the right of the ordinary person, and by extension of the ordinary person, the media specifically, to go in there and observe those proceedings, even if we're not a litigant, which is what family court's been about in Nevada since the beginning. Since 1865, it's really just been a right of the litigant to be involved, at least in divorces.
We have shared the oral argument, just gavel to gavel,
Mhm.
on Utah Family Law TV. And so, and in fact, we've talked about the fact that you would be interviewed about your take on that. And then UFLTV is going to run the oral argument again with breaks and pauses for commentary from me on that after taking that in. Now, I did watch the oral argument twice before talking to you, and so in the time we have remaining, I thought it might be interesting just to get your take, or the take of the legal team that represented
Okay.
you, on a couple of things. Now, I'll say a couple of things, and this isn't going to spoil it for those of you that are looking forward to watching the oral argument, folks. But um, clearly, the thing, and you and I have both, we both run a similar operation. Whereas we want to provide media access to public proceedings, specifically in my case with family law domestic relations proceedings. I don't know about a judge's has a broader scope, but in this particular case, they were talking about family law proceedings mostly. I think that'd be fair to say. And so, a couple of things that I thought were interesting is the one thing you alluded to earlier, and that was, well, Your Honor, if people get to know what's going on in this family's divorce case, or parentage or child custody case, then I remember Mr. Willick said that the children will be mocked at school the next day when all their schoolmates find out about what happened. Well, you and I both know that the odds of a child wanting to watch domestic relations court proceedings are fairly slim, and that even if they did, frankly, there's a good chance, like that Simpsons episode, where Milhouse's parents are getting divorced, and so Nelson comes up and says, "Hey, Milhouse, I heard that your parents are getting divorced." He's like, "Yeah, what are you gonna do? Say ha ha?" He's like,
Mhm.
"No, far from it. I just wanted you to know that I sympathize with you. After all, I too come from a broken home." So the
Yeah.
fact of the matter is you'd be pretty hard pressed to find kids that are going to mock a child for having his parents get divorced, even though kids can be cruel. But my point was is that they say these things about, well, wouldn't it be awful if people know this? Well, the fact is, the public already does know. When people get divorced, the neighbors notice that mom or
Yeah.
dad moved out. When
And
they get divorced, they see the moving truck. The kids
yeah.
will. So what we're really doing is saying, yeah, there may be some dirty laundry that gets aired. There may be some skeletons in closets that get opened, but it's not as though we didn't know these things exist. The closeted gay husband, the pill popping mom,
Yeah.
the infidelity, whatever it is. But uh, that happens in any other case that's open to the public. You know what I mean? You can have an embezzlement scheme that turns out the guy was funneling money to his mistress and snorting coke and stuff like that. Apparently,
Yeah.
you have no problem there. And then with the criminal, like you say, we have nobody seems to have any problem with public access to criminal proceedings, where those are embarrassing as all get out to
Even
to
we
the
can
accused.
even when
And
they spill out from family court, which is so silly because we've already been covering those. We have
yeah,
family court cases that spill into to criminal court, and it's all the same stuff. It's all the same stuff, and we're recording the trials and stuff. It's just the most arbitrary thing. You know what I think they're trying to do when they bring up these fears is I think they're trying to really them, as in not just Marshall Willick, but the other opponents, which are the American Association of Matrimonial Lawyers and the Family Law Section of the State Bar. Basically, the other side is a whole bunch of family court lawyers. That's the other side. What I think they're trying to do in a way is almost just speak directly to the family bench bar, the family divisions, the family court judges and lawyers, and their fear that what what they see a lot in those cases is the parents putting the kids in the middle and the parents telling the kids what's going on in family court. And they take, I think, this one fear and they try and make it seem like media coverage is going to take that one thing and make it 1,000 times worse. But if you really sit down and think about it, it's a completely different thing. When two parents are talking to the child or the children about what's going on, it's like they put the kids into this tug of war and force them to pick sides. But when third parties and observers are involved, that's a completely different thing. These other people aren't trying to put the kids in the middle, they're trying to see what's going on. So I feel like they're trying to conflate these two issues. And the funny thing is, whether observers are in the courtroom or whether the media is covering a case has no bearing on whether the kids are going to find out. The kids are going to find out from those parents. So if there's bad parents that are doing things they shouldn't be doing, us being involved or not involved has no effect on what those bad parents have been or will do anyway. It's not like us being involved is suddenly going to make the parents start doing these things that they shouldn't be doing with their kids, namely to put them in the middle and to try and get them to choose sides. That's something that they're going to do whether or not the media is involved, if that's going to happen.
in
But
fact, in fact, I think that children that are too young to understand what's going on can't be affected by this. They might they might come across an archive and
yeah,
learn some things later. But children that are in their teens, it's like, in a way, you're saying, well, kids, rather than having to take it from mom or from dad or grandma or grandpa or something like that, you can see what's being argued in court, which
right.
frankly, if parents were to know that, they might be a little more they might exercise a little more discretion in the way they present their cases.
That's one of the
Uh,
things that my lawyers talked about is they were questioning whether or not it was even an issue. So this is an interesting idea that comes from the opponents of transparency, that there is a benefit to the children being deceived, and not even just the children, but the other family members. And my lawyers specifically were like, is it really a problem if like say the aunt or the uncle or even the kids, which I agree with you that they're not going to be that interested until maybe they're way older, find out the truth about something? So I mean, and this is assuming that in these cases that are high conflict cases, they're being lied to by both parents. It's interesting to me that
Exactly.
the idea that a child who's being lied to by both parents who are in a power struggle suffers from seeing the truth later on. I wonder if these ideas have really been questioned and studied. There's some studies from, I've heard there's some studies that were cited from the opponents of transparency. I haven't looked a whole lot into them because they seem to be self-serving studies where they just wanted to reach the conclusion that they'd already decided to reach. But I really do question how much harm comes to a family finding out the truth rather than believing what they're being told by the litigants.
I couldn't agree more. The idea being that basically ignorance is bliss is what it comes down to, is that
Right,
what a child does not know cannot hurt him, which is false on its face. Because as you pointed out, that the child is going to learn something from some source somewhere
right,
about these disputes. And so if they can get it from what's in the court record, which of course you can lie to the court, you can
right,
lie about what goes on in court, but at
right,
least they know what was being said, and they're not just getting it from one side or the other.
right.
And like you say, they're already in the middle because it's their family.
And
uh,
here's another thing that doesn't make any sense. And none of this is the purpose of coverage or access, but this is just dealing with some of the odd sort of arguments that the opponents have. So then there's this other argument that what about information that they don't want to get out to the public that they do just want to keep in the family? Well, there are so many situations, at least in Nevada, where these cases are sealed and the courtrooms are closed and the information is still getting out anyway by one of the litigants. So
right.
we don't have, the problem isn't solved by sealing the case and closing the courtroom. The litigants themselves are in many of these cases going on to social media. Some of them are doing interviews on camera. I don't know if you've seen the Alex Jones situation where he got his wife to agree to seal the case and then he started talking all about it on his radio show. So I think a lot of times people say,
Yeah.
well, if you seal and you close the courtroom, then you keep the information from getting out. But there's nobody that's
Right.
policing the actual litigant. The litigant is still going out and talking about the case. It's still going out. So that's
Right.
the
It'd be naive and unrealistic to suggest that the courts have the power with the stroke of a pen to protect a child from any of these things you just discussed, because the information is going to get out one way or another, and typically it's going to get out in some incomplete or adulterated form.
yeah,
So you're not doing the child any favors if that's what they're exposed to.
and that's another thing is that the media can write about a case without having access to the case. If the media can't go into the courtroom, they can still write about the case. They can still talk about the case.
A
So
very good point, where you could say, look, you can either let us you can either, courts, let the record speak for itself, or you can let some subjective journalist talk about it.
yeah, so
Which is going to be more accurate and even-handed? There's no question.
right. So I guess we only have 3 minutes left. So I did at least want to, I guess, give your viewers a summary of what I thought about the proceedings, just
Please
to
do. Thank you.
really, it's what I mentioned. It's two sides. It's the media and myself and the public trying to get access versus a bunch of family court lawyers on the other side trying to get in the way of it. And the general confusion is that a lot of people think it's our side wanting access anytime and the other side wanting to block access anytime. That's not the case. Our side just wants to give the judges the discretion to weigh whether or not access is appropriate, which includes considering parents' privacy, child privacy, and the public's right. And then our opponents, which are saying categorical denial of access to family court is appropriate. So I feel we have the more reasonable position. If we prevail, the judges still can consider the public interest versus the parents and close the court. If we lose, then what's going to continue to happen in Nevada is categorical denial of access to family court. I think we have the more reasonable position. It's in the middle, and I think that we're probably going to come out on top because it's the more reasonable position.
Yeah, not to be glib, but as it's been said, sunshine's the best disinfectant, and electric light is the best, most effective policeman. And applying it to your situation, sunshine is what's going to make sure that public trust in the courts and understanding of the law is best. And electric light, being the camera in this case, is like the cameras are going to help people understand what goes on. And I think that you probably downplay it a little bit, but it's nice to know that the courts are subject to public oversight so that they don't get drunk on their own power or start to take liberties, knowing that there are people that will hold them accountable because the public votes. And
Right.
so, but again, I appreciate the time that you've spent with us. And we will. So, for those of you that are hoping to learn more about this, you can go to Our Nevada Judges to watch those proceedings and other proceedings and other content that's on Our Nevada Judges. And then we have it on UFLTV, and then we'll have the commentary coming shortly. Thank
And
you so much for your time.
And the last thing I was going to say is just remember, we've already been recording family court cases. So if you do as Eric Johnson said, and you go to the Our Nevada Judges website, you can actually find family court cases that we have already been recording, and the sky has not fallen, and the world did not implode, and everything is just fine. So I'm going to get going now, and thank you for having me.
Thank you.